Welcome for today's presentation. In contract law, we have 6 elements. There are offer, acceptance, consideration, legality, capacity, and mutuality. So for today, we want focus on offer. What is an offer? According to Contract Act Section 2 subsection A, when one person signifies to another his willingness to do or to abstain from doing anything, with a view to obtaining the assent of that other to the act or abstinence, he is said to make a proposal. The person who made the offer is called offeror, and the person to whom the offer made is called offeree. In short, an offer is proposal by offeror to offeree to enter into a legally binding agreement. The concept of offer is crucial in contract law, as it forms the basis for the formation of a legally binding agreement. To be considered a valid offer, 3 elements must be present. There are intention, definiteness, and communication. Intention. The offeror must demonstrate a serious intention to be bound by the terms of the offer. This means that the offeror intends to create legal relations and be legally obligated if the offer is accepted. Definiteness. The offer must contain clear and specific terms such as price, quantity, duration, and any other essential terms that would be necessary for the parties to understand their rights and obligations. Let's see the facts of Goosing versus Lynn case. The buyer, Lynn, of a horse promised the seller that they would pay £5 more for the horse, or buy another horse from the seller, Goosing, if the horse was lucky. But Lynn did not keep his promise? The issue was whether the offer could be considered to be a valid offer or not. Specifically, whether the terms lucky and buy another horse could be defined and considered legally binding on the parties. The court held that the condition to pay £5 extra for the horse if it was lucky was deemed to be too vague to create a binding contract. As a result of this, the only part of the transaction that was sufficient for the court was the purchase of the horse for the price of £63, and that was the vast majority of the legal agreement. Communication. The offer must be effectively communicated to the offeree, ensuring that the offeree is aware of the terms proposed. Communication can be made through various means, such as in writing, orally, or even through conduct, as long as it is clear and explicit. Let's see the case of Taylor versus Laird. The claimant was employed as the captain of a ship which was owned by the defendants. Whilst in a foreign port during the course of the voyage, he voluntarily gave up his position as captain, and worked as an ordinary crew member during his passage back to Britain. The defendant was not made aware of this change of position. Upon his return, he sought to claim wages from the defendant for his work as a crew member during this journey. The issue was whether the defendant had accepted the claimant's offer of work despite being unaware of it, and by extension whether the defendant was contractually bound to pay the claimant's wages for his work on the ship during the return journey. The court held that the claimant was not entitled to wages for the return journey on the basis that he had not entered into any contractual agreement with the defendant for the performance of his work as an ordinary crew member. The defendant had not received any communication or offer of work in this capacity from the claimant, and there was therefore no basis for a contract. The court reasoned that it would be unjust to hold a party bound by an offer which he had not been made aware of, and therefore had no opportunity to accept or reject. As such, it is not possible in English contract law to accept an offer in ignorance. Offer divider into 2 types. Firstly, general offer. A general offer is an offer that is not made to a definite person but to the world at large or public in general. In general offer, the contract is made with the person who, having the knowledge of the offer, comes forward and acts according to the conditions of the offer. Another invitation to treat. An invitation to treat is a concept within contract law that means an expression of willingness to negotiate. It is not an offer to enter into a contract, but rather an invitation to a party to make an offer. The example of invitation to treat is advertisement, auction, self-service outlet, exhibition on the window shop and catalogs. Hope all of have understand about offer. Thank you.